Honorable Commissioners, Senior Counsel Murgor, good morning. We are now ready to start our session this morning. Senior Counsel Philip Murgor, welcome to this interview. We hope that it will be more of a conversation with you, between you and the commissioners. And please relax and answer the questions as precisely as you can, Senior Counsel. So the interviews will be by all the commissioners. And as soon as those pictures are taken, we are going to introduce ourselves. So just 1 minute and then we introduce ourselves. I think that is enough. So, Senior Counsel, we introduce ourselves. My name is Professor Olive Mugenda, chairing these interviews. I am a commissioner representing the public. And on my right,
good morning, Senior Counsel. I am Philomena Mbetemwelo, the elected representative to the Judicial Service Commission by the Supreme Court of Kenya, and I am the Deputy Chief Justice of the Republic of Kenya.
Good morning, Council. I'm Patrick Eshohi, representing Public Service. Karibu.
Good morning, Senior Counsel. My name is David Majanja, Judge of the High Court and a male representative for the Kenya Magistrates and Judges Association.
Good morning, Senior Counsel. I'm Oluwande Everly, a Chief Magistrate. I'm representing the female representative, KMJ as the female representative.
Good morning, Senior Counsel. My name is Machere Njero. I represent Law Society of Kenya, you being one of them, at the Commission.
Good morning, Senior Counsel. My name is Felix Koske. I represent the public.
Good morning, Senior Counsel. My name is Mohammed Warsame, Judge of Appeal. Welcome.
Thank you.
Very good morning, Senior Counsel. Kehara Kariuki. I am the Attorney General, and I'm on this panel by virtue of my being in that office.
thank you very much, Senior Counsel. If you are not sure about a question, you are free to ask the commissioners to clarify or to repeat the question. And I'll start by asking you to tell us your county, Senior Counsel, and your ethnicity. As you know, we are required by the Constitution to take care of diversity.
First of all, allow me to record my appreciation at being here this morning before this esteemed panel of JSC commissioners. My county, I have two counties. Actually, I have three counties. I was born in Elgeyo Marakwet, the place where all the champions in the country come from, so I hope not to let them down today. My parents settled in Uasin Gishu County. That is where I have my country home. But the larger part of my life, up to the present days, I live in Nairobi County. But having said so, that on the question of counties, I'll go to the question of my ethnic background. I am a Kalenjin. You mentioned that you are expected to take care of diversity. A Kalenjin happens to be the community that is not represented on the Supreme Court. So I make that also clear. And the third question, your Madam Chair, was?
I think that is it, but okay. We need one county. Which is the county in your ID?
My ID, it would be Uasin Gishu.
Wasigishu. Do we go by that?
I think we'll go by that.
Okay. Thank you very much. So tell us, Senior Counsel, who is Philip Murgor in terms of the person, the lawyer, and the leader that you want to be?
I would be, I think, remiss in going straight to the lawyer that is Philip Murgor or the senior counsel that is Philip Murgor. I would have to start with who I am as a person. First of all, I'm a husband to a judge of the Court of Appeal in this judiciary, Justice Agnes Murgor. I am a father of 3 young adults, 2 girls and 1 young man. I am everything else to my entire family. But this gentleman, Philip Murgor, was born in 1961 in Elgeyo Marakwet County. He grew up there. He was born there. And at that time, my parents or my father was in the provincial administration. And that required that he travel. At that point in time, he was in the town of Iten. I then grew up in another town, Kiambu town. I grew up in Kisumu a little later, and by 1970, the family relocated to Eldoret in Uasin Gishu County. I stayed in that, I grew up there until I finished my primary school. I moved to Nairobi for my secondary school and my university, and I have not left Nairobi since. So the person you see, insofar as outlook or worldview is concerned, is a person who is easily described as a Kenyan. A Kenyan that does not see any person from an ethnic lens. Philip Murgor, the person you see here, went to school in national schools. And I will take you straight to my secondary school and my university. I went to University of Nairobi, and I finished my law degree there in 1985. I went back in 2011, or a bit earlier, and finished my master's in 2011. I got my master's degree from University of Nairobi. I have several other qualifications, but I will discuss that perhaps in another question. Apart from that, I would like to say that as a child, I grew up in a polygamous home where there were 4 ladies privileged to call themselves wives, many children. Throughout the span of that polygamous family, both of my parents have passed on, but eventually there were 18 children. Why I say this and why it is relevant is in that a competition who has passed on was very close to me. She is the person that made me what I am today. She taught me the virtues of fairness, kindness, compassion, and I salute her today. I'm here because of my mother. She worked hardest to bring me to where I am today, and I'm grateful. So that is Philip Murgor. For that reason, I will tell you this, and I am not apologetic at all. I am an avowed gender equalist. I believe in the equality of women with men. I believe in the equality of girls to their fellow children, the boy child. And it brings me, and it will perhaps bring me in this same conversation into certain explanations that I will give why I may not attract the sympathies of those who are male chauvinists or those who feel the woman is a lesser person in this country or the girl is a lesser child. So that is Philip Murgor.
Yes, the next one, the next part of the question was Philip Murgor as a lawyer.
Philip Murgor as a lawyer, first of all, I would address the misconception about Philip Murgor as a quick one. Philip Murgor is a very soft-hearted, understanding, gentle when he needs to be kind of person. And I'm talking about him as a lawyer. But to bring you to the point where I'll ask you to come to that conclusion, I will go first to, at the University of Nairobi in 1982 when I joined. One morning in the month of August, I got caught up in the famous or the infamous abortive coup. I was a first-year student. There were tensions in the country, and somehow, somewhere, I found myself in a situation where, after the events had subsided, a few weeks later, I was arrested. I was arrested with a group of about 60 students who, for one reason or other, were found to somehow have participated in a demonstration that came under the grouping called sedition at the time. We were charged with quite a few people. And whenever people talk about 1982, you all recall that the former Chief Justice Mutunga also got caught up in the period and was incarcerated. And we have one or two other notables. But having said that, what is the relevance to Philip Murgor as a lawyer? The relevance is that for 6 months after the arrest, apart from spending a few nights in the cells, both in Eldred and at Central, we came to this building, which is the Supreme Court building today, for mentions every 2 weeks. There was a requirement for mentions every 2 weeks, and spent the whole day in the cells, which are now the very beautiful rooms that comprise the museum. At that point, they were not as beautiful. They were extremely badly kept. They were smelly. And it was, and this is relevant because I'm talking about what the judiciary was at the time, the cells were kept in a manner that would prevent you from getting too used to being in trouble. They were meant to punish you from the time you were charged. Having said that, it took about 6 months for the Office of the Attorney General then to find out that there was no evidence to prosecute the charges. And one day, as surprising as we were charged, one day we woke up and came to court and the charges were withdrawn. Several individuals against whom there was some evidence went on to be prosecuted and even convicted. Philip Murgor, as a lawyer, has been shaped by those events. It has made me a person who reflects very hard when he deals with issues relating to law and justice. When anyone complains about being a victim of the police, of the prosecution, of the judicial system, I listen very carefully because I know it is possible. I know it happens. I cannot ascribe the events of 1982 to corruption. I would ascribe it to politics. But today, victims of the justice system are they mainly come through other processes, including corruption in the investigation process, the prosecution process, and sometimes in the judicial process. The other event that, so anyway, I finally got released and went back to school. The universities had been closed for the full period that we're incarcerated, so we lost no time. We went on to finally graduate in the next 2 or 3 years. And another aspect of this becomes relevant. I consider myself above average as a law student. And why I say this, I don't consider myself brilliant. I know who were brilliant in my class. They went on to be professors and all the rest of it. But why I mention this is I had choices after I finished my university degree. I did my pupillage in the top law firms. And I should mention one of my pupil masters was the Honorable, the Attorney General, Commissioner Kehara Kariuki. I was at Hamilton, Harrison and Matthews. And I can say that at that time, you might not know it now, but those who were in school at that time, there was a general classification as to who joined the private sector, remained in the private sector, who joined the state law office, who joined the judiciary. Those who thought they were most articulate as advocates went straight into the private sector to earn the money. Those who were less endowed with speaking skills or advocacy might have joined the state law office. Those who didn't know how to communicate but were otherwise good at their books joined the judiciary. But generally the classification was that those who joined the public service were those who didn't have choices. I must say the transformation that has been made in the judiciary has completely changed that. Today, the best students want to join the judiciary. The best students want to join the state law office and all the rest of it. But I mention this in my context. And what is my context? As I finished my pupillage, I had the choice of remaining in the private sector. I had offers from good law firms, one of which was the one I had done pupillage with. But I chose public service. I said that is where you get your right, your proper grounding as a citizen. You should go in and serve the public. I joined the public service. I went for my interview at the state law office. I was very easily taken, and another important event took place after that. At that time, people joined the state law office for as short a time as it took to get another job. And if the Attorney General or his staff made the mistake of transferring you, you simply downed your tools and left. So I was called into a meeting by the then Solicitor General and said, we can't quite believe that you really want to work for the government, but you seem to be keen. Now, the next step is the harder one. As your first posting, we want to send you to the provinces. And if you say you will resign, we need you, we will not transfer you. So we're giving you the choice. We request, would you take a posting out of Nairobi? And I asked, and where would that be to? And he said, to Kisumu. We are understaffed, we need a good person. And I said, Kisumu is Kenya. Why not? Everybody was happy with that. And I went off to my first posting in Kisumu and stayed there for 3 years before duty called. I was retransferred to Nairobi, and My history is on record. I was a very diligent public prosecutor at the time. I handled cases well beyond my pay grade and I did get married while I was in the state law office. I should point out I met my beautiful and wonderful wife at the state law office, and so Commissioner, Attorney General, I know there are good people there who are marriable even now. But I want to say that I got married there and I carried on, and in 1992 I finally found it a little difficult to raise a family within the terms of service at the time, and so both my wife and I left to set up private practice. So that is a significant part of a history that I would like to tell. I should also tell you that I did try and stay. I'm not a footloose civil servant. I don't pick up and go when I have a choice. I tried to work the system, to recognize the work that some of us were doing, but the system wasn't like it is now. It is far more responsive now. At that time, it was expected that you would want to leave anyway after a few years. And I remember writing a long letter explaining why I left, and when I finally saw that letter many years later, the then Solicitor General had said, noted, place on file. Nobody cared. Nobody cared for good service. Nobody cared for committed service. Now, in the time I worked as a public prosecutor, as a state counsel, I worked very closely with the judiciary. I worked very closely with the resident judge in Kisumu for the 3 years I was there. In a small town, or in a smaller town, Kisumu isn't that small, the intricate workings of the public prosecution's office and that of the judge or the judiciary is such that you work together to reduce backlog, you work together long hours if necessary to handle appeals so that people stay in prison properly or have the benefit of appeals being successful. I got to understand it as no one would in the private sector. You're in public service, you're working with a judge, you're working with the judiciary staff, and it's second nature. When they can't proceed, they tell you. When you can't proceed, you tell them. So that was my experience in Kisumu. When I came to Nairobi, more or less the same, much bigger setup. It's public service, it's understanding the position of the judiciary, understanding where they have challenges and where you have challenges. In the public prosecution's duties that I had, I would spend my whole time in court. I spent my whole time understanding the tribulations of my colleagues, who by then of course were magistrates. Prosecutions are undertaken before magistrates, and appeals before the then High Court, and then of course the Court of Appeal. So when I read about the history of the judiciary and the words used in the transformation manual, I identify with it. I know what the judiciary was. I know how it was not responsive. I know how it was not people-centered. I know how it was generally seen to be, in civil matters, the preserve of those who had money. And I saw how, of course, those who didn't have money got shortchanged. I mention this because very often a state counsel defending a conviction or a position taken by the lower court would be alone against an ordinary citizen who had no counsel. And I'm not talking about those on capital convictions where there would be a pauper brief assigned to an advocate. I'm talking about a citizen against you. You know, there is no equality of arms. But as a state counsel, having the heart to sometimes defend the convict. And when I say defend, plead the case of the convict. And I'm talking about a situation where you look at a record of appeal, and somehow, despite the conviction and the sentence of several years in prison, or even the sentence of death, you can't find the evidence to support the conviction. And in the role of a state council, it would be your responsibility to easily and happily concede to the fact that the conviction cannot stand. So I am alive to what the judiciary was at the time. I moved then to, having resigned in 1992, I went into private practice. I set up a practice from scratch. When I say scratch, I mean scratch. A couple of desks this size, one for the secretary, very thin walls as partitions. I think I recall we borrowed a couple of 100,000 shillings and set up the office. I have all these years been able to grow that practice until it is a well-known practice. It has been fairly large. Through this practice, we have handled, mentored many students, many advocates who have worked with us and left, and kept the flag flying. In this practice, I have handled many briefs. I have represented a president of the Republic. I say this and it will become relevant later. What am I saying? I don't belong to the category that will look at the President of the Republic as some godlike figure. I look at the President as a person who I can speak to, who can communicate. And in the case of that particular president, Daniel Arap Moi, the late, he was a good client and he took legal advice. He would ask twice, so is that your advice? But that is in passing. I go on to explain one or two other briefs that put me in contact with various other arms of government. I personally handled the famous or infamous, the briefs that arose from the infamous Goldenberg scandal. And this was a brief that was passed to me on account of my public service experience, my diligence, my commitment, despite all the temptations that would go with such a brief. In that brief, I don't want to go into the merits of it, I came in contact with ministers, with governors of central bank, and other powerful individuals. It was a classic case where it took collaboration between agencies within government to succeed. And I must say, this in passing, when I handled those briefs, His Lordship, the late Justice Kokar, was the Chief Justice, and it was a very happy experience. Cases were handled fairly expeditiously and with a fair measure of success. I say this because, and perhaps this is something that will feature later on in the interview, the administration of a particular Chief Justice defines the output, the expectation from that judiciary. And I say this with great respect to the departed Chief Justices who I'm going to refer to. Central Bank had a fair measure of success in some of its cases under one administration. And when there was a change of administration, and we had a different Chief Justice after Justice Kokar, suddenly the fortunes in those cases changed. And I will say this because it's a matter of record. And certain judges who had ruled in a certain way shortly before ruled in a different way. I can only say that it is what the leadership of the time showed to the judiciary, gave you a sign about what was permissible and what was not. I don't want to say more for legal reasons, but that is the story of the Goldenberg cases through the courts in our country.
Maybe Senior Counsel,
Yes.
I could pick it up from there about leadership, because you have talked about the different people and their leadership styles, and ask you, if you became CJ, what is your leadership style? Is it democratic? Is it authoritarian? Could you just tell the Commission what kind of a CJ we would expect if you became one?
My choices are democratic, or do I have any choice?
You have choices, just explain to us.
Okay. Thank you, Madam Chair. I will have to go back a little. Actually, not back, a little forward, which is where I was going. And permit me, with your kind permission, Madam Chair, I will answer that question by then talking about, it was on account of my diligent handling of the Goldenberg cases on behalf of the public, meaning I was responsible or retained to try and recover the billions lost. Due to circumstances beyond my control, I left those briefs, and several years later, when there was a change of administration, I was selected without consulting me and appointed to become the Director of Public Prosecutions. Now, I will answer the question of leadership in the context of my role as the Director of Public Prosecutions. I was dragged kicking and screaming to the desk of Director of Public Prosecutions. And after I settled down to the fact that I had no choice but to once again serve the public, I had a leadership challenge. And this is how I explain my role and my qualities as a leader. I found a small, demoralized team of State Counsel / public prosecutors at the State Law Office who had absolutely no interest in what they were doing. They didn't care. They went to court. They went through the motions. They weren't proud of winning a case because nobody around them cared. And I come to something that has featured in some of the interviews I have watched. I had no money to offer them. I had no improved terms to offer them. They knew exactly what they required to perform. There is always a list in public service. When you ask a public servant what would he require to perform better, he'll tell you and he'll list down what he requires. When I looked at the appointing authority's expectation, which was the NARC government that had come on board or come to power on a platform of anti-corruption, the demand of me was that I sort it out immediately, get work done, and start prosecuting effectively. So my leadership style comes in. I have to talk to these demoralized colleagues of mine and first of all convince them that it is public duty, it is patriotism, it is a country they are serving, and in good time, which I promised was not going to be a very long time, there would be an improvement on their terms. I had support from the concerned agencies, all the way from the Treasury, from the Office of the President, and so on, that would come in due course. So my management style was one, first of all, leading from the front, Whatever it needed to be done, I would do it with my own hands. If it required me to go to court myself, I would do it. And many times when the cases were of a sensitive, in a serious nature, with a lot of pushback, even politically, and I would see the nervousness on the faces of my colleagues, my juniors, my reports, I would go to court myself and lead by example. I am therefore, I lead from the front, I am consultative, I am empathetic, and maybe I should give the Commission one of the real-life cases I had to handle. Shortly after I was appointed, I was interviewing for my department. And I had this young lady who said she wanted to work for the department, and she had lived for it. And I said, from your papers, from your interview, you qualify, but you seem to want to say something. And I said, what? And I asked her, what was it she had to say? And she said, I'm getting married shortly after this interview. And I will only take this job if you will assure me that I can go for my honeymoon. Because if I don't go for my honeymoon, I might lose my newly wedded husband. And I said, I give you my word that if you take the job, you will go for your honeymoon. I will not stop you. Even though you're not entitled to leave, I will ensure that you take some days. So she came on board, and within a few days, she wrote a memo asking for a few days off. And I said, I gave you my word. I will take responsibility, and I will explain your absence at the inductions that were looming. And I did put in a memo. She came back from her honeymoon, and after the month ended, or shortly after that, she got a memo telling her for failure to attend the induction, she would be punished. She would have to reimburse the government the entire amount that was used on her so-called for failure to attend. And she came back in tears, said, I now have to leave the government because I haven't earned anything, and I'm being told I will not earn anything for 2 months. And indeed, the end of that month, she got nothing. I took it up with the Attorney General. It became a crisis for the office because the entire office stood with her. And I took it up with my boss, the Attorney General, and I said, this is not right, this is not fair. And if I was at fault for having given her the permission, I would pay her salary. It took a push and pull, and finally her money was reimbursed, returned to her account, and it moved on. The office was replete with those examples where you just had to be human, just had to understand the problem. So at the end of the period that I was there, which wasn't very long, I know I was that kind of leader. I kept everybody together. We performed miracles. The terms of service were not improved at the end of the first year for reasons that might be evident in some of the documents that I transmitted to the Commission. We were being frustrated by the accounting officer of the office. He didn't seek enhancement of our budget. But what I'm trying to say is I stayed with the team. I played with the team. And you're talking about leadership style. Despite numerous opportunities I had to travel and see the world and attend conferences, some important and some not important, I didn't think it was an important thing to do when you're in an important job in the public service. I stayed at home, traveled very little, and worked as hard as I could. So that's my leadership style.
Thank you very much, Senior Counsel. I will now request the Honorable Acting CG to ask her questions. CJ, sorry.
Thank you. Senior Counsel, what would you consider to be the role of presiding judges and heads of station across the country what would you consider to be the main challenges they face? Because they are the decentralized leadership out there, and what solutions would Senior Counsel offer as Chief Justice?
Thank you very much. And Madam Chair, may I ask for the liberty of referring to everyone as Commissioner and then their name, to shorten the titles.
Yes, we can.
So, Commissioner Mwilu, thank you very much for the question. I appreciate it. And I am grateful that I was given the opportunity in the last few minutes to explain my role as the DPP. There weren't very many state counsel in the Department of Public Prosecution, so I'll give you a number, 50. Today there are hundreds. But in the context of your question, my role during the time I was DPP is identical in some shape or form to the responsibilities of a presiding judge. You are the head of a unit or a department or a group out in the provinces, and you are in charge of all matters that arise. You are in charge of ensuring their output. You are in charge of discipline at the first level, taking complaints and making inquiries. And you are in charge of ensuring they stay motivated. They stay motivated. And in your, the judiciary, and I should call it ours for the purposes of this interview, in the current state of that is, of course, ensure performance as far as the performance management outputs are concerned. Insofar as problems are concerned, the problems that I have described for the DPP are no different from the problems that existed at some point for presiding judges. But today's problems, to me, appear different. Today's problems indicate a situation where today, meaning there is no Chief Justice, and I say yesterday, and when I say yesterday I mean it figuratively, perhaps in the tenure of the previous Chief Justice, I have discerned from a memoranda that was submitted by the KMJA that to some extent there was a bit of a disconnect between the administration of the immediate past Chief Justice and the presiding judges in some of the work they were doing. So my solution, if I were honored to be appointed the Chief Justice, is to be a Chief Justice who, to use another description for leadership, a walk-around leadership style, where you spend a lot of time visiting your colleagues in the divisions, in the counties, in the magistrates' courts. I think I would spend far more time visiting them, listening to their problems, of course accompanied by the appropriate team of administrators, so that some of their problems are attended to as quickly as possible, because I think in many cases it's a question of communicating the problem and somebody responsible enough hearing the problem. That's my solution, Madam Commissioner.
Senior Counsel, did you say that the situation is different now because we do not have a Chief Justice?
I said, as long as it is not a Chief Justice, the chief situation may not change. And I am not saying that the acting Chief Justice is not doing her best. I am simply saying it is not the same as having a Chief Justice, because the Chief Justice ultimately is responsible. Anyone in an acting position does not really is also acting for a temporary time. So you don't start anything that you can't finish.
Is it Senior Counsel's considered opinion that then, for these last 4, now almost 5 months, there's been a vacuum in the judiciary?
It is not an opinion, it is a fact. There is no substantive Chief Justice in office.
No, the question is vacuum. Has there been a vacuum?
I have not done a survey to ascertain what it is that would be described as a vacuum. I will only say I go by what is current and available to me, and I go by what I have read very carefully in the memorandum of the KMJA. So they are not concerned, they're not dealing with your performance as an acting Chief Justice. They are talking about the past administration, and they are talking about what they hope for in a future administration of the office of the Chief Justice. So I wouldn't want to pass any judgment on your performance as acting Chief Justice for the last 4 months.
Let's close that particular discussion on asking about the limitations to the execution of duty of an acting Chief Justice.
I beg your pardon?
What are the limitations, if there are any, known to you about the execution of duty of an acting Chief Justice?
I think the law is quite clear, the Constitution is quite clear. The acting Chief Justice shall do as much as they can while awaiting the appointment of a substantive Chief Justice. So the limitations are found in the word acting. When I say acting, it means exactly what it is. When you run an institution and your term is based on awaiting the appointment of a substantive holder of the office, every single person in that office views you through a certain lens. You are temporary in that office. For example, if you took a decision that in some way affects them, there would be the expectation that if the process was not concluded by the time there was a new Chief Justice, that decision could be reviewed. So what I'm trying to say is, and it is meant with no disrespect to you in your performance, I'm talking about what I know to be the outlook of any public servant when dealing with an officer who is holding office in an acting capacity.
Thank you, Senior Counsel. Had you not raised that question, we wouldn't have discussed it. But the more substantial question is, in your considered opinion, what you think an acting anyone is limited from doing. I want to suggest that your view, which you are 100% entitled to, is yours. Mine is completely different, and I think the law abhors a vacuum. There cannot be a vacuum, and I am not aware that the acts of an acting director, Chief Justice, would be reviewed on account of having been executed during the period of acting. But let's go to more substantial things. And the next one is this. This institution is run, at least since 2011, on certain systems with certain leadership positions and management tools that help the institution to achieve its core mandate, which is to make access to justice available to all Kenyans. Please tell us some of those systems that are already in place in the institution and how Senior Counsel, as Chief Justice, would either enhance or strengthen them, or what alternatives Senior Counsel Chief Justice Murgor would employ
if I became Chief Justice.
if you became Chief Justice.
Thank you. I start, first of all, by recognizing the great work that has been done in transformation. It's unimaginable. As I explained earlier, I was there at the beginning. Perhaps I was interacting with the judiciary long before many in this room. So I know the wonderful work that has been done in the area of transformation. And I take this opportunity to salute Chief Justice Emeritus Willie Mutunga in that regard. Well, first of all, on his vision. It's truly revolutionary. I also congratulate immediate past retired Chief Justice Maraga for the work he did in sustaining some of those transformation measures. So, and maybe I should go on to say, and the entire team of existing judicial officers who today, Madam and Commissioner Mwilu, are led by you. Plenty has been done. Plenty has been done. Now, you ask me what I would do to improve it.
The first part of the question is the systems already in place, and then what you would do as Chief Justice to either improve the existing systems or your own systems that you as my Lord Chief Justice would then develop.
I am going on and I was developing it. What I would do, and I need to then identify what is the problem that it would then require me to do anything. In an ideal and optimum situation, which is what it is not, if I were to have come in such a situation, I would simply ride on the train and let the systems run themselves. But the situation is not optimum. The situation is not ideal. There is a huge challenge. There is a huge challenge. For example, on the issue of capacity, which affects access to justice, it is greatly affected by the staffing issue. The staffing issue, and in particular, I'm not talking about the 40-50% to bring up the judiciary staff to 9,000. I'm talking about the judges that need to be appointed, and then I'm talking about the funding issues, which would then enable rollouts of ICT and everything else, and recruitment. That is the challenge. So I'm not coming into a situation or a job in order to carry on and improve. I'm talking about a situation where the ship of the, if I may liken it to a ship, merely, the ship of, that is the judiciary, which is a huge organization now, far larger than it ever was, is slowing down. It's grinding to some sort of halt. So it's not a question of improving, it's a question of what can I do, or what will I do to ensure that the system doesn't stop altogether. I was thinking about this problem, and I likened the problem facing the judiciary to the recent massive container ship that got stuck in the Suez Canal. It's called Ever something, Ever Given. Modern ship, the best captain, obviously, all the technology in the world, sailing down the Suez Canal, and somehow something went wrong, something small. Lost control, the ship turned to one side and got stuck in the canal. It caused a huge pile-up of traffic on both sides, a slowdown in world trade. For those who had to go around the Cape in South Africa, higher costs, slower delivery of services. From where I sit as an advocate, I can see that for the last 1 year, there has been a slowdown in the delivery of services to the public. And that problem has featured in every conversation for the last 1 year. It is on account of the failure to appoint a certain number of judges, cutback in budget. And Madam Commissioner Mwilu, please permit me now to explain what I would do. I consider those two as the causes of that slowdown. I consider that as the thing that, or the issue that has to be dealt with as a priority by any incoming Chief Justice. I sit here on this chair today in the firm belief that it is unlikely that anyone in the ship that is called the judiciary can get the ship to move on. Like the ship in the Suez Canal, the captain must have tried what we all do when we get stuck in mud, engaging first gear and reverse backwards and forwards and hoping to get out. But it was obvious after a very short space of time that the only people, or the only intervention that could resolve the issue of the ship in the Suez Canal was external intervention. There had to be tugboats on the outside, there had to be excavation on one side or both sides, and finally the ship got going. I bring that analogy to the issue of the judiciary. For 1 year, the administration of the judiciary, and forgive me for saying this from where I sit, which is not 100% informed, I include the JSC in it, have, whatever means they've tried to engage, has not resolved the problem that has led to the crisis in the judiciary. There could be many reasons. I could hazard some of them. My personal view that the Honorable, the retired Chief Justice, speaking on the steps a few meters away from here to everyone concerned, might not have been the best solution. But whatever it is, it didn't work. And one of the questions I would have to ask...
Counsel,
yes.
Senior Counsel.
Yes, Madam.
That is, to you, only one aspect of our failure, according to you, to deliver optimally for the last 1 year. I was asking for the systems inside, but so that we can make progress, I shall just mention that we have systems in here that are called LMTs, Leadership Management Teams. We have the CUCs, we have the JLAC, which is the topmost governing body that assists my Lord the CJ to deliver. But while still on that topic, and so that we can get out something that we are looking for, let me ask the next question, which is a part of the roles of the Chief Justice. There are many of those. We will not ask a simplistic question there, but let me mention this, that one of the roles, Senior Counsel, you will have to perform if God grants that you be the next Chief Justice of the Republic, is to make rules and regulations as mandated by a number of statutes. From the background of legal practice, and knowing as I do that you are forever in these courts, please tell us the challenges you have faced will lead you to regulating, making what rules for the effective enabling the institution of the judiciary to effectively make it possible for Kenyans to access justice and for the legal practice to effortlessly earn their keep.
Madam Commissioner, first of all, perhaps you will allow me to finish my answer. Because it also dovetails into exactly what you are asking me. So the problems of the judiciary today that require outside intervention is, in simple terms, a different approach. As the old saying goes, when you are in a hole, stop digging. The other saying goes, don't do something in the same way all the time, months in, months out, and hope for a different result. So, solve the problem of capacity, the appointment of judges, solve the problem of the funding, and the ship will continue moving, justice will continue flowing, and who knows, you don't need outsiders like us coming to tell you what to do. As for the rules and rules made by the Chief Justice, there is absolutely nothing wrong with the existing rules, and where necessary, the relevant committees will look at them, having taken feedback from all other affected agencies, court users, bar bench, and those are framed and finally promulgated following an agreement and consensus on what is required. So I personally, as a practitioner, have no problem with rules at all.
Thank you, Counsel. Thank you, Senior Counsel. Let's go to a different area now that I have to cover within the time given to me, which is this. Counsel, listen to this. Senior Counsel, listen to what I'm just about to read. Judicial power to nullify a law duly passed by the representative process is a restriction upon the power of the majority to govern the country. And I'll take that again. Judicial power to nullify a law duly passed by the representative process is a restriction upon the power of the majority to govern the country. Briefly and with guided answers, would Counsel kindly discuss that?
That really is the power of judicial review, and that power exists in our courts, and I'm not sure there is anything more I can say to that. The courts have the power to review some executive actions. In addition to that, the courts have power to declare certain legislation unconstitutional, declare certain actions by the executive unconstitutional.
All right.
And it is in itself, as you say in your question, the power to check the excess of those who at a certain point of time might be in the majority. So it protects the rights of minorities and those who may not have the power to legislate for their protection.
Thank you, Senior Counsel. In your opinion, is there a contradiction between the mandate of the institution of the judiciary under the constitutional framework and the principles of judicial restraint?
Please come again.
I'll take it again. In your opinion, Senior Counsel, is there a contradiction between the mandate of the judiciary under our constitutional framework and the principles of judicial restraint?
I'm not sure that I quite get your question. A contradiction between the judiciary and the principles of judicial...
We are told that the Constitution has told us what we must do.
We are told that
the Constitution itself has told us,
yes,
has given us our roles in Chapter 10.
Yes.
Out there, then we are told, and therefore the judiciary must continue to discharge its duties to the best of its knowledge and ability under Chapter 10 of the Constitution. You will hear that the judiciary must exercise restraint. In fact, if I left it there and I said discuss, what would Senior Counsel say?
You know, you make it sound, Commissioner Mwilo, like we are in an exam. But my answer, my short answer is, and I suppose we are, or you are alluding to the subject of judicial activism and its limits, or what are its perceived limits, whether it is desirable or not. But my short answer is this. I don't know who has told you when you say we are told, but I'll take it that that is a criticism that has been leveled at the judiciary by some quarters. For my part...
Senior Counsel, if you live in this country, you have heard those statements all the time. That the judiciary is doing things that are not theirs, they should not annul laws, they must not... Remember, we are covering a certain topic. They must not legislate from the bar, they must from the bench, etc. There must not be activists, they must exercise restraint. That is as simple as I can make it, Senior Counsel.
You know, perhaps I'll answer it by answering a question that I had expected Madam Chair to ask me for, as I started. What is my judicial philosophy? Then that way I will give you an answer that stands in a certain position.
That is on the one that we are covering right now, that actually is my area.
Madam, I will answer your question in the way that I see fit. So please give me a bit of time. So I believe there are two philosophies on either side of a spectrum. There is the progressive and there is the conservative, and then in the middle there is what I would call the moderate philosophy. I belong to the moderate philosophy. So in answer to your question, too much of either side is not good. Too much conservatism, too much progressive interpretation is not good. In the positive spectrum, a judge supplants his personal, political, or other views on his interpretation of the law, and you get a situation where you start at point A and you end up so far away that when you look at the section or the article that is under consideration, you can't recognize it. So, to the phrase, there should be judicial restraint, I subscribe, in the sense that one must limit themselves to the limits provided under the Constitution. Now, when you look at our Constitution, as it has been described, it is very progressive. And if it is progressive, many of the articles allow for a purposive, for example, a purposive interpretation. It gives the judge some leeway in interpreting that section. The phrase or the criticism that you refer to as judicial restraint is simply a comment that can be made by a party that feels aggrieved by that decision, that even as you interpret an article, you should exercise judicial restraint. You can go so far, but don't go too far. So that is my short answer.
Senior Counsel, I thank you. Let us go still under the same topic to the Constitution. Emeritus Chief Justice Mutunga once said this, which I quote, "It is unusual for a constitution to be as preoccupied by the question, scope, methodology of its own interpretation as Kenya's 2010 Constitution." I'll read that again. "It is unusual for a constitution to be as preoccupied by the question, scope, methodology of its own interpretation as Kenya's 2010 Constitution." Now, Senior Counsel, as our interactions, I hope I should have actually started there, with the Supreme Court's decisions, particularly those concerned with constitutional interpretation. And now this is a question. What are your views on the court's position, the Supreme Court's position on constitutional interpretation? The second limb of the question, distinguish for us, please, what you consider to be the methods and objectives of constitutional interpretation, and whether it is possible to generate progressive and contextual jurisprudence utilizing the tools of strict constitutional interpretation. Are we still together?
You've lost me. I'm not sure even you are with the question.
Yes, I am.
Please repeat it.
I am with the question because I'm the person asking the question. It took me time to come up with the question.
Okay.
So I know the question. And it is this. And it exercised the mind of Chief Justice Mutunga as it exercises mine today, and as it has exercised the minds of many counsel in this country when they discuss the work of the Supreme Court. Chief Justice Mutunga was of the view that the 2010 Constitution was so subjected to discussion as to its scope, the methodology of explaining itself, explaining as into interpreting it. And so, I ask, part of the criticism the court has received is that it does not know what it does when it is interpreting the Constitution. And here we are looking for your views
as to whether or not they know what they're doing.
That, and whether or not there's a difference between, there are many ways of interpreting the Constitution as the Supreme Court currently has constituted, understood its role, and as any interpretation it has applied to the Constitution being restrictive to creating jurisprudence. I hope now you understand.
I will try and answer your question as I understand it. I first deal with the Constitution. There are those who have studied the type of Constitution we have, and as much as it is described as the most progressive Constitution and the best Constitution on the continent or in the world, there are many who are prepared to concede that in being so elaborate in scope and methodology and even in trying to interpret itself, it lends itself to very many interpretations, so that those who achieve what they want through certain interpretations of the Constitution are happy with it, and those who feel aggrieved by that interpretation are not happy with it. In the early days, when the Constitution was first promulgated, these comments, there were many discussions about what else it could have been. And I was one of the individuals who thought the same Constitution could have been concised into a statement of principles, like, for example, the United States, rather than one that seeks to almost be legislative in nature, to provide for every single situation, so that when it does not, it creates a problem. When it provides something and it overextends itself in both scope and methodology, it creates a different problem. The problem that you are now referring to is how the judges in the Supreme Court themselves understand it. And it may explain why they have come under some criticism. But I have, as much as I have been before the Supreme Court, I have not worn the shoe of the judge who has had to make these determinations in various matters. So I will not pretend that I can criticize them, I can second guess them, because while I read the decisions that come out of that court, I don't read all the arguments that are presented to them. So I would request that it be permitted to be the extent of my answer.
Thank you. Thank you, Senior Counsel. This is the second last question I ask. If God grants that you be the Chief Justice, you will require to be the team leader in the policies of the judiciary. Please discuss with some emphasis on some of the key policies that we have adopted in the 2019 to 2023 Judiciary Strategic Plan as the role of the Chief Justice. Then I'll ask you the final question on the Supreme Court as President, and that will be my last one.
I would request that you ask the question once again.
As Chief Justice, you would be the team leader in developing policies that is the way we do work here and to enable us to achieve our core mandate, the reason for which the judiciary was established. And so the question is, with a bit of emphasis on access to justice, please discuss a few of the policy issues that we have discussed in our 2019-2023 strategic plan.
I'm sorry, madam. Your question is not specific enough for me to answer it. Maybe I should put it this way.
Have you interacted with the 2019-2023?
I have it here.
Good.
But what I would like to say is this. I don't fault anything that you have done so far. the wheel has already been invented. So my job, as I come in, if I, as you know, as you say, if God wills it, is to make sure it works.
Senior Counsel, we are testing as a commission. You are having interacted with the policy and understood what it is we think will enhance access to justice between 2019 and 2023. We are not asking for critique. We are trying to get to know that you have interested yourself sufficiently in the workings of the judiciary to see its strength, to see its weaknesses, to see what you are coming to fix. And so the specific question is, on what we have seen as our strategic priorities for the period 2019-2023, that we have already put those already. The work is done for you, for us as a commission, and for us to be able to assess you, it is to see what you have taken out of that and what you would do differently if you came in as Chief Justice.
I'm trying to make my answer simple. I would do nothing differently. I would make sure it happens. I would provide the necessary leadership for the judiciary to implement what is otherwise an excellent strategic plan.
All right.
Yes.
Give us the specifics of the strategic plan that you consider excellent towards access to justice.
I'll deal with one. Let us deal with the question of access to justice by way of enhancing technology. Technology, in my view, is the way out of most of the problems facing access to justice.
Sorry, are you still ongoing?
Yes.
Yes, then finish that.
I see a situation, and I have read all the documents prepared by the judiciary. I have seen how access to justice has been dealt with regard to the people, with regard to the culture, with regard to the physical facilities, with regard to manpower. When I say people, I mean manpower. And I see, in the light of all the challenges that the country is facing today, a lot of rationalization needs to be done. You need to relook at the planning aspects of all the development projects and rationalize them so that rather than having 62 courts that are incomplete, rather than having ICT projects that are in the pilot stage, stuck in a few courts, rationalize them so that you are able to complete a few projects. And the one that has the biggest impact on access to justice, on the delivery of the core mandate, which is justice, is developing, rolling out, fully covering the country with ICT capability in every respect, from end to end.
All right.
Yes. So if you tell me to run with something, I would run with that.
All right. Thank you, Senior Counsel. I said my final question will be on the court at which you would be president if God were to grant that you be the Chief Justice. That court has had occasion to deal with certain cases, a number of them, to enable our initial vision of being the court that has promoted alternative dispute resolution mechanisms. Would you like to discuss one or two of those cases and tell us what the decisions were?
The decision that has
enhanced alternative dispute resolution mechanisms, or even discussed the issue of alternative dispute resolution?
The one that comes to my mind is the one that, under discussion, is the, was it the, the one that comes to my mind is 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 The one that
I could actually mention two of them.
Yes.
One is Synergy, a famous case, and the other one is Newto.
Yes.
There is a line of them there. But could you then tell us, those two, what was their input? What were they concerned about? How have they helped us to be better at promoting alternative dispute resolution?
Newto's decision is the one I had in mind. And I'm grateful you asked, because I am also an arbitrator, and I also undertake and also conduct arbitrations. It was quite disturbing in the manner that the string of decisions had gone to create a situation where there was no longer any certainty about finality of arbitration decisions. So Newto put that back in good stead, that the whole idea, not Newto actually, it's, I actually should say that I'm in agreement with the decision of the retired Chief Justice, that there should be a finality in the decisions.
In Newto?
No, it's the other one.
No, it wasn't Newto, but thank you very much, Senior Counsel. That will be the end of our discussion, and I wish you well.
Thank you very much.
Thank you, Chair. Sorry, thank you, Chair.
Thank you, Commissioner Acting CJ. I would like to now ask Honorable Commissioner Judge Wasame to ask his questions.
Okay. Senior Counsel, once again, welcome.
Thank you.
You talked about the principle of judicial restraint, which is to allow the legislature and the executive more freedom to formulate laws and policies. How will you align that with judicial activism or adventurous tendencies by the courts, especially in the court where you tend to be the president?
I did mention, Commissioner Warsame, that I don't subscribe to extreme judicial activism. And at the same time, I don't subscribe to total restraint and conservative interpretation of the Constitution. I subscribe to the philosophy whereby, where it is clear there is room for purposive interpretation, then a court is required to and should proceed along the path of interpreting the article in question in order to make, in fact, they say the purposive is in order to give effect to whatever the Constitution was trying to provide for.
Now, you are a criminal lawyer, of course, been the DPP.
I practice criminal law.
Yes.
I'm not a criminal lawyer.
Yes. Thank you for the correction. You have read maybe the Murgor case.
Yes.
Which said at section 204 of the penal code, insofar as it provides for a mandatory sentence, death sentence is unconstitutional. And the court gave some direction that the Attorney General, the DPP, the Speaker of the National Assembly and the Senate to do certain things. Would you consider that decision to be an aggression on the part of Parliament and the people of Kenya? Because the penal code under 204, as read together with 203, 296(2) of the penal code, the one which deals with robbery with violence, and treason. Those are capital, they provide for capital punishment. Under the Constitution, which our Constitution, you termed it as progressive, Article 26, I think so, either 26 or 25, provides for death penalty, provided it is prescribed under the law. What is your view?
About Murgor or about what the Attorney General
the Murgor case?
I have no qualms or problems with the final result in the Murgor case. I think it is sound reasoning.
In terms of it is import,
Yes.
and how it has been misused to even provide for other offenses, like the Sexual Offences Act, and you know, for example, 2962. What is your view?
Now, my Lord, with your permission, and I will not name names, but you and I might know what we're talking about. There was once a case where there was a fight and it resulted in a death, and there were two individuals involved. One pulled the trigger, one might have been involved in an earlier altercation. And I recall in that decision, the judge said, since somehow these two issues are connected, without the fight, the subsequent pulling of the trigger would not have occurred. I find both of them, the judge found both of them guilty. Now, Murwatetu specifically dealt with that kind of case. The culpability, the responsibility of both actors is completely different. When the first gentleman was having his verbal altercation, he could not have imagined that it would have ended up with his friend doing something, pulling a gun and pulling a trigger. So to that extent, I understand the persuasive reasoning of the Supreme Court in that regard, where there should be qualification, there should be scope for determining, for punishing responsibility by way of the sentence to be meted out. When the second part of it, or the other part of that, when you mentioned it, when the court requests that the matters be placed before the Attorney General to consider legislation, amendment of legislation, I also have no quarrel with that. Now, I'm coming to other types of acts. I think every act should be looked at on its own and what it is intended to do. The case of murder, it was simply a case of the old teachings in several holy books. Eye for an eye, you kill, you are killed. But over time, that qualification is being made by society. The death penalty is being abolished and so on. So there's a movement in a certain direction. But in the case of other statutes, I may have some reservation. For example, I didn't mention it, Madam Chair. I have been involved in wildlife conservation, in particular fight against trying to stop poaching of elephants. Some years ago, I was the chairman of a group that very successfully agitated and ensured that was done. And in the course of all that, we dealt with the levels of involvement in handling game trophies, so that if you are found with so much, you are deemed to be this and deemed to be that. And the only way that it could actually be a deterrent is, and we're now not talking about murder, which sometimes is simply a crime of passion and it's a series of events that end up in death. When you are dealing with things like narcotics, when you are dealing with things like game trophies, the message that the legislator wanted to send out is, if you handle an elephant tusk in a certain way, you are guilty of a certain offense which provides for a minimum. So there is where I personally would find some difficulty. So I would prefer, if there's any question regarding a particular statute, I would express myself.
Okay. Under Article 143 of the Constitution, the President of the Republic of Kenya enjoys immunity both from criminal and civil cases during his tenure. In one of the decisions in the Olekewa case, we said, if the president decides to sack, for example, 20 judges on the same day without following the correct procedure, he does not enjoy immunity or protection. What is your view in terms of criminal prosecution or civil prosecution of a sitting president in terms of the article. What does the article talk about? Actual things which the article is talking about. In your interpretation as the President of the Supreme Court, CJ Murgor.
Now, my Lord, I see a situation arising.
And you have the option not to answer. You can say pass.
I know I want to answer it by not answering. In this way, when you put forward a hypothetical situation like that, I think it's unfair to a person who you consider may end up in the Supreme Court. Because should he be faced with such a situation, he would have already expressed his view. And it would be the first order of business to disqualify that judge. So these hypothetical situations have their examples that are posed as questions have their dangers. So I would request that it is...
Can the President sue personally? I'm leading to other questions which will come. During his period as President of the Republic of Kenya, can he sue personally?
I think by the same vein, you know, that's exactly the same situation is arising. You know, if he were to sue personally, if the question arose as to whether he can, it would be a justiciable issue which would end up coming up to the courts. So I would prefer not to also express my view.
And I want you to express your view. Does the Deputy President enjoy the same immunity under 143?
Again.
And I want your view. I want you to answer, because if the reason why we're here, we want you to know your views. We are not saying there is anything wrong with expressing your views.
There is absolutely everything wrong in expressing a view about a matter that may become a reality in due course, for whatever reason, or not a reality. If I was interviewing for Director of Public Prosecutions, I might have answered your question. But I am not interviewing for the Director of Public Prosecutions.
Okay.
I am now going to sit as a judge. I have no view that is worth putting out, because I must be seen to have a blank mind when I will hear anyone in such a dispute, on such a question.
Senior counsel, I'm a judge. I was involved in the Olekiwa case, and I expressed my view. You can sue the President if there is a clear and dire constitutional violations in his personal name.
How did you express your view, my Lord?
In the Olekewa case.
As a judge?
As a judge.
And I assure you, when that question comes before me, and I am a judge, I will express my view.
Okay.
Yes.
Now, under Article 144 and 145, the President can be removed on grounds of incapacity.
Yes. Yes.
Under Article 147, one of the functions of the Deputy President is to act as a President when the President is temporarily incapacitated. If there is a conflict and the Deputy President says, you want to start 144, but I am the Deputy President of the Republic of Kenya. Therefore, 144 cannot kick in during my term. How will you rule?
How can I tell you how I will rule? You might make me the Chief Justice. How can I tell you how I will rule in advance?
Okay.
If you were confronted with the same Olekeiwa decision before you had ruled, would you have told the whole world what you would have done?
You see, you are on that chair, and you are the one who is seeking to be the President.
My Lord, I request your pardon.
I have no problem.
I am saying
I have no problem.
I am saying the question is, I have asked it by way of asking a question.
Yes.
I've answered it by way of asking a question.
Okay. Under Article 144 and 145, which involves the removal of the President. If the President is removed under one of those articles, is he entitled to approach the Supreme Court? And how will you deal with that case? And that's why I was asking you the immunity of the president under 143. Because this one is his personal, because he's removed as the President of the Republic of Kenya under 144 and 145. Can he now approach the Supreme Court in his personal name, or the decision of the tribunal and parliament and the Senate is final, according to you?
My Lord, you are asking me to express a view on jurisdiction. If I would...
Let's go to the next question.
Yes,
Yes.
I can't.
Yes.
Yes.
Article 146(2)(b) provides in the event of a vacancy in the office of the president, the DP takes the office. In the event the DP is not available, the Speaker of the National Assembly. But the Constitution is silent in the event the Speaker of the National Assembly is not available. Who will be our president?
My Lord, on a light note, I was reading it, I saw the gap, and I said to myself, it might be the Chief Justice. And in the absence of the Chief Justice, it would be the Deputy Chief Justice. And in the absence of the Deputy Chief Justice, the senior most... What am I saying? I cannot speculate. It says what it is. If it is a matter that there is a gap in the law.
Senior Counsel, you are right, because the first stop is the legislature. The third stop is the judiciary.
Yes, but those who drew up this constitution, those who are framing the laws now, those involved in amending the laws right now, those are the things they consider. The Chief Justice, the judge of the Court of Appeal, like you, the judges of the Supreme Court cannot go into that arena where they are filling in gaps in such a substantive manner.
Okay, and this is my last question. The question of review of punishment, of sentence, conditional pardon, substituting sentence is ordinarily reserved for the judiciary. Ordinarily reserved for the judiciary. Tell us one instance where the President of the Republic of Kenya can exercise judicial function.
In our law, it provides for presidential pardon.
Tell us one instance where our president can exercise judicial function as a sitting president.
I see what you're asking. You're saying he seems to be performing the judiciary function. Where do we perform?
I didn't say judiciary function, I said judicial function.
You have asked a question where you've said, show me one.
I said, tell us one instance where our president, the President of the Republic of Kenya, as a sitting head of the executive and the government, is allowed under the Constitution to exercise judicial function.
He doesn't exercise a judicial function. He just exercises his presidential powers.
I wish you well.
Thank you.
Under 33, Article 133, it's a judicial function. Thank you very much. I wish you well.
Thank you very much, Judge Wasame. Thank you, Senior Counsel. It's now the turn of Honorable Commissioner Justice Majaja to ask his question.
Thank you very much, Chair. Good morning, Senior Counsel. You presented 5 sample writings for consideration by the Commission. The first one, submissions in a case you argued.
If I may just pardon me, please permit me, Commissioner Wasame. Madam Chair, he put article of the Constitution on the table and then said, thank you very much. In fairness to me, I am looking at the article. At no point whatsoever under Article 133(1) is the President said to be exercising a judicial function. It might be his respectful view, but it is not worded so in the relevant article. Thank you.
Judge Blessana, do you want to respond? Oh, okay. Thank you. Thank you, Judge. Noted, Senior Counsel. Go ahead, Judge Majaja.
Thank you, Chair. Yes, Senior Counsel. Yes, you presented 5 written samples of your writing. The first one is submission in a case, Laser Isle Center Limited versus PDM Limited. This was a landlord and tenant case. Unfortunately, I believe one of my fellow commissioners is cancelled in that matter, so I will not pursue that particular case. The second one is an arbitration. An arbitration you did, and you told us, actually, there are 3 very important cases the Supreme Court has decided on this issue. Can you please tell us which cases are these?
Which ones?
I'm asking, in the line of arbitration, there are 3 important cases the Supreme Court has decided. 3 important cases.
The one I'm aware of is the Newt one.
Yes, the Newt one. And then the other
I
one?
said that's the one I'm aware of.
Yes.
That comes to my mind.
You are aware of the Synergy?
No, not quite.
Are you aware of Geochem and Kenya Bureau of Standards?
No.
Okay, because the Bangalore Principles, which, you know the Bangalore Principles, there is a principle on diligence and competence, isn't it? What does that mean to you, diligence and competence?
Both the ability to understand the law, to write the law, and to deliver on time.
Deliver on time. And one of the aspects which, as Chief Justice, when the magistrates will be coming here, is the duty to keep up with the latest decisions of the Supreme Court. You know, Supreme Court is the Supreme Court, and part of its jurisdiction is to give precedents that are binding on all courts. So that's why I'm asking if there are 3 important decisions on arbitration. Is something somebody should know. But that said, what is the ratio of those 3 decisions? What exactly is the ratio of those decisions vis-a-vis the law of arbitration?
There should be finality.
In what way? What is the ratio? That there should be finality.
In the sense that after the arbitrator has rendered the award, with exceptional circumstances, there can be an appeal to the High Court, but after that it is final.
Okay, I'll leave that. Then you have, there's another written piece here on Murgor developers. These are matter which I presided over, so I will not deal with it. And then we have submissions in Rose Wangui Mambo. This is submissions in reference to a taxation. I dealt with the primary issue, the issue concerned costs. I will not deal with it. And finally, submissions in Samuel Muhia, Kariuki, and others. This is about pyramid schemes. Is this matter complete yet?
No, I believe it is on appeal.
It is on appeal,
Yeah.
so I will not touch it. So you've given us these sample writings, which you have made it very difficult for us to pursue, isn't it?
Well, I didn't do that deliberately. It was all done in a bit of a hurry. But I should say, my lord, and with great respect, that I understand sample writings to be more a question of determining whether somebody can write in English and communicate more than what his thinking is and what is, because that is a question you can ask directly.
And the questions I can ask now, if I ask you about this case, I will be influencing whoever will determine those cases, you see.
So it wasn't deliberate.
Okay. So there is something we call horizontal and vertical application of the Bill of Rights. Can you tell us what that means and whether you think it's important, that distinction between horizontal and vertical?
I think you'll have to explain your question.
No, my question is horizontal application of human rights and vertical application. That is the principle.
My understanding is that human rights are not only inalienable, but they are the one thing in the Constitution that must be observed by everyone, all institutions, and in particular the judiciary. So whichever way you look at it, either horizontally or vertically, it is something that is paramount.
Okay, let me go to a hypothetical, and you may or may not answer me. Peter and Mary are married. Okay?
Yes.
They have a child. In fact, they have 3 children. Peter took out a mortgage with a bank. But because of COVID, he is not able to maintain payments. He's lost his job. That has caused problems in the house. They have had a dispute. They've gone to the children's court because of that dispute. The children's court has said, okay, Peter, you move out, let Mary stay in the house. The bank is on Peter's neck. They issue a statutory notice and they advertise the property for sale. Mary goes to court and says, look, I have a right for housing. First of all, I have a right for shelter for the children. Then I have a right to housing. And I want an injunction restraining the bank. Given the nature of the rights, is it a case where the court would consider giving an injunction, and why?
That is an interesting hypothetical situation, because the bank has its rights. The couple have their rights. The child has some rights also to shelter and protection. To my mind, it would be wrong for a court to give an injunction against the bank on the face of it and on the plain reading of the documentation.
Okay, let's put it this way. Mary is saying, I have a right to housing against the bank. It is there in the Constitution. Give me an injunction. So what is your answer in respect of the right to housing in respect of the bank?
No, Mary doesn't have a right to housing vis-a-vis the bank.
Why?
Because of the commercial nature of the bank's relationship vis-a-vis that property.
But
you didn't say whether the lady wife signed on the mortgage and was fully aware of the mortgage, because
let me put it this way: does the right to housing depend on whether you have a mortgage or not?
Yes.
Does the right in Mitubel? What was the issue in Mitubel, for example?
The Mitubel was one of these more contentious cases where the High Court went on an interpretation that went into the intendment of the Constitution. And I saw the reasoning of Her Ladyship Justice Ngugi, putting some responsibilities on the government to provide for the families, for the wives, for the children, notwithstanding the fact that the people on that land had no right to be on that land.
So what did the Supreme Court say?
In the Court of Appeal, and the Supreme Court subsequently stated that they couldn't help those people, except directed in the case of the Supreme Court that the parties could go back to the High Court and argue their rights on account of the breach of the court order. There was a court order at the point when the respondents leveled the informal settlement.
Okay.
So it's at large. It's in the light of that, one would say that the Supreme Court did not recognize those rights.
Did not recognize the right to housing?
It recognized the rights to housing, but not in that context, and not in the manner that they had argued it. Yes. So it said there is a right to housing.
I want to understand that right to housing. How did it recognize? Or you are now the Supreme Court. How would you recognize the right to housing, either for mother and child in that situation, or for the people in Mitubel?
In Mitubel, I think the situation is a little distinguishable in the sense that it was government land, and the position taken by the Supreme Court is that the government ought to come up with policies on what it will do when it evicts people on government land, which, they should be sensitive to where they go and so on. In the case of the mortgage, that arena is one where the Constitutional Court would hesitate, or I'm even saying the Commercial Court would hesitate to enter. If the bank has outstanding money and it wants to realize its security, I would suggest respectfully that the best that a court of equity would do was perhaps hold the position, and that means giving an injunction, and allow a small period of court-appointed mediation where the rights of the lady and the children can be catered for without a situation where the bank simply goes in and because the man has an obligation to maintain his family.
And does the bank have a duty in respect of the right to housing?
No.
Okay. There's something called the doctrine of avoidance. What do you understand by that doctrine?
In which respect? In the same case?
In terms of you being the Supreme Court, adjudicating on issues, and there's a doctrine, just like the doctrine of mootness, there's a doctrine of avoidance.
Well,
no, I want you to tell
in
me,
the
because
sense
it's common.
of avoiding tackling an issue.
Yes.
Yes. It's self-explanatory.
Yes, okay.
Yeah.
Why is the doctrine of avoidance, the doctrine of avoidance about avoiding certain issues, why is it important in the growth of jurisprudence? Why is it that a court can take a stance of avoidance in order to develop the law?
It all depends. I think it comes back to a question I was asked earlier about judicial activism, and in fact it was touched upon in the Murgor case, where one of the parties, I don't recall, I think it was one of the civil society parties, started asking for more and more orders in the course of arguments, and the court said on certain issues it had not been properly argued, had not been responded to as it should have been, and it invited the parties to deal with it in a different forum another day. So why is it important? I think it is important because at all times the court should seize itself of matters that are properly before it, rather than go wandering off in search of issues to resolve and make determinations upon. Otherwise, we use the term, it becomes per incurium.
Yes, but what I was asking is, how does that contribute to the growth of jurisprudence?
It doesn't. Jurisprudence will grow by itself. It doesn't have to be go at a super rate by every judicial officer looking for issues to make determinations upon.
You mentioned the case of Murgor, and you also referred to the case in which you were involved in, the one of Dixon Mwangi, isn't it? Dixon Mwangi Munene. That's the word you were talking with my colleague commissioner. In Murgor, what was the ratio of the Murgor case?
The ratio in the Supreme Court?
Yes, the Supreme Court decision.
The ratio was that the judicial officer properly seized of a matter should have discretion in determining the extent of a sentence based on circumstances.
And how did the court reach that conclusion?
By looking at the fact that in the circumstances of Murgor and all other circumstances similar, once a judge had found that a person was guilty of murder, as the case may be, they had no discretion save to sentence.
But what was the principle drawing from the Constitution that the court was saying?
It ought to have discretion.
Yes. What was the basis of that principle? What is the basis of that finding? Okay. So you talked about Dixon Mwangi Munene, and the issue you were talking about basically is common intention, isn't it? That you are the one probably who was out there waiting with the car, and the person came and you went with him, or you're the one who brought him with the knives, gave him, and something to that effect. How does Murwatetu deal with common intention? Because that was the issue that was in the Court of Appeal, isn't it?
Yes.
Whether this is the principal actor and this is. So how does Murwatetu deal with the common intention? Or how does it affect common intention? Does it deal with the doctrine of common intention?
It requires a court to deal with and consider the question of common intention.
Yeah.
It doesn't go into it in those circumstances, but it deals with the principle.
Okay.
Different facts, different considerations lead to different sentences, should lead to different sentences.
Okay. A major part of your work in the Supreme Court will deal with the election petitions. And one of the issues that will be critical is the issue of the burden of proof in election petitions. So, two questions. What is the burden, the standard of proof, in the law in Kenya, and why, how do you justify that standard of proof?
What is the burden of proof in
The
election
standard of
petition?
proof
Yes.
in election petitions in Kenya?
It is on a balance of probabilities.
Are you sure? Okay. Then we'll move to the final issue, and this is now to what you told in answer to the questions my colleague, the chair, asked you. You agree with me that, as you have ably said, the history of a man or a woman, the experiences are what mold you, isn't it? And you and I have some common history somewhere. We went to a very good school somewhere, and that has molded us in a sense, isn't it?
Absolutely.
Yes, the Hill School in Eldoret. So we have a common history there. So you talked about your experience in university, which that was in 1982. And I think for Kenyans, that period is very, it's one of the turbulent times in Kenya, where many things happened, and some of them well documented, some not so well documented. And then you went to the state law office, correct?
Yes.
So you were in the state law office until 1992. Am I correct?
Yes, you're correct.
Okay. So you recall that you prosecuted a case of George Anyona,
Yes.
Edward Oyugi,
Yes.
Ngodo Kariuki,
Yes.
and Augustus Kathangu.
Yes.
You were the prosecutor.
Yes.
And maybe I may not get the facts right, but please correct me, because these matters appear to have been scrubbed off the internet and other sources. So these men were arrested having certain documents at Mutugi Bar in Dagoretti Corner. Am I correct?
Those were the facts.
11th of July 1990.
I don't remember the date, but go ahead.
Yes. And they were brought to court and the trial began. They were not given bail, correct?
Yeah, possibly.
Possibly.
Yes, I'm waiting for the question.
No. I want us to lay the factual basis, because
It's a long time. I wish I had
yes,
noticed.
it's a
I
long
would have,
time. But as I said, these are pivotal part of our history, and I think we must get it right. That's why I'm putting it to you,
okay.
because you are the prosecutor. So if you don't know, you don't know. But I'm just putting them on record so that we are very clear. So they were denied bail. They were not given bail for sedition. And they were arrested in July 1990, and the trial began on 10th January 1991. Now, the four of them alleged that they were tortured. Am I correct?
I don't recall.
You don't recall. And then you were the one who prosecuted them, called several witnesses, and you produced a confession. Is that correct?
Just carry on.
No, I'm asking whether you just tell me. I want it on record that you don't remember.
I recall eyewitnesses and so on.
Yes,
and,
you
and
recall
not,
eyewitnesses.
as to the specific evidence that was produced, to the detail,
Yes, but there was a confession, okay? And there was a trial within a trial before the magistrate, Honorable Francis Mabele. Am I correct?
That I remember the trial magistrate was Mabele.
Yes, Mabele. By the way, I was a young boy then. And the issue of torture, they laid evidence of torture at the Nyayo House chambers. Am I correct? You don't recall?
Yes, these are, what year was it? As in
This
quite a long
was,
time ago.
1991.
Yeah.
1990. 1990, I was in Form 4. So, at the Alliance High School. And they laid evidence that they were being tortured. And you resisted that application, of course, as the prosecutor. And the confession was admitted. Am I correct?
Possibly. I'm waiting for the question.
Thereafter, the trial came to an end and they were convicted.
I remember they were convicted.
How many years were they convicted for?
I'm not sure.
Okay. 10 years, 9 years, you don't remember.
No.
So the issue I'm asking, you know, you have told us that in 1982, you were arrested as part of a group of people who were alleged to be coup plotters, people who had taken part in the melee here in Nairobi.
Actually, it wasn't plotters.
Oh, not plotters, but
yes,
people who are...
Certainly not plotters.
Yes, what I would say the resgestai of the coup, the people who are, you know, swept up in all that melee, whatever it was.
That's why you need to be specific.
And that is why I'm saying you correct me, because this is historical. I told you I was still a young boy. So you were swept up in that. And from your own words, this was a very pivotal part in your experience, isn't it? So you were swept up in all this maneno of the coup, students rioting or whatever. But it was in that melee of the coup, isn't it?
Just make your question, please.
No. I am putting to you.
You know, you are saying things, and some of which I don't recall, some of which may not be true. But I would prefer you get to the question.
No. So if they are not true, you tell me they are not true, because I wasn't there.
Okay, we were not. It wasn't rioting.
It wasn't rioting.
Yes, certainly.
So what were you accused of?
Of taking part in a demonstration.
Taking part in the demonstration, and this demonstration was in relation to what?
The coup.
It was in relation to the coup.
Yes.
And you were brought here to the court, isn't it?
Yes.
Of course, you were denied bail.
Yes.
You went through that harrowing experience.
Yes.
So that is something that it was a big event in your life.
Certainly.
Yeah. So here you are. A few years you come to the DPP's office. The same men, and you recall the same Anyona people had been detained at that time. Am I correct?
I'm not sure in terms of time perspective. I'm not sure.
Yes. So are you aware that at that time Anyona was arrested, 1982?
Generally, yes. But
are
detained,
you aware
I'm not sure
that arrested or detained? You know, you were the adult, I was a child. In fact, in 1982, I was in Standard 3. So, you have Anyona, you have Edward Oyugi. Had they been subjected to the same issue in 1982?
I don't
No idea.
No.
You have Gotho Kariuki. Was he subjected to the same issue in 1982? You don't remember? You have Augustus Kathangu. Was he subjected to the same issue in 1982? You have no idea. So you have been experienced that event. It has been a pivotal part of your life. Then come 1990, you are met with the same or similar circumstances, isn't it? People plotting to overthrow the government. That is what sedition is, isn't it?
Yes.
They've been caught up.
Sedition is not plotting.
So what is sedition what is sedition?
In the context, it's preaching disaffection.
Preaching disaffection. But isn't that the same genre of
Go ahead.
threatening a government, a lawful government.
Go ahead.
It's the same genre, isn't it?
Yeah.
You agree with me?
Yeah.
So 1982 that happens, 1992, but now you are the prosecutor, and I'm not blaming you for that. Probably somebody has to do the job. You prosecute these men rigorously to the best of your ability.
Rigorously is your word.
Yes, and I'm putting it to you.
No, I
vigorously.
I undertook
Here-
my duties with the necessary
Here
competence.
they allege torture.
Yes.
Mhm. They allege that they had been tortured into confessing. And in fact, from the accounts of that day, that trial within a trial took quite some time. Maybe you correct me because you were the one who was there. I wasn't. So the long and short of it is this. 1982, you undergo an experience. 1990, you undergo an experience. Now you want to be Chief Justice. Are you the kind of person we should risk to be the Chief Justice, knowing that these kind of events may happen?
Now,
That is just the question.
which kind of events may happen?
1982,
Uh-huh.
1990,
Yes. So, which kind of events are likely to happen
the
now?
kind of events where
Uh-huh.
students like you are picked up from the street, brought to the court after hours, I presume, denied bail, and then told to go home afterwards. Yes? 2, people meeting in a bar, Mutogi bar or whatever bar, arrested and told, you have written a piece of paper, possible nominees for certain cabinet ministers, therefore you want to overthrow the government. Isn't it something, as a Kenyan, in fact, let's go back. Is it something you regret? Is it something you regret? Is it something you have reflected on? Your position in that particular situation?
Commissioner, I want to say this.
Yes.
I was a professional.
Oh.
I was working in the state law office. I was undertaking my responsibilities. You have been an advocate in private practice. I recall, you have done cases which are simply your client's cases. The question of whether or not you agree with your client's case is something that is neither here nor there. Having said that, you have described a trial that took place involving certain individuals. If I was the magistrate, perhaps some of your questions would have been relevant. But I was simply the lawyer advancing a case for one side. There were others advancing the opposite case. So what you call torture, what you call a trial within a trial, was a contested issue upon which there was a determination by a magistrate. If the determination by that magistrate was the opposite or the contrary to his final determination, that would have been a matter that would have been squarely within the purview of the magistrate. I prosecuted a case. The fact that I had an experience that was similar or not has no bearing on the fact that I am now undertaking a responsibility for a client. Otherwise, a lawyer, be he a government lawyer or an advocate, would be totally incapacitated in handling their duties. I conducted a case. There was an outcome.
Okay.
There was a conviction. Where does my personal regret come in? I was doing the duty of an advocate on the government side.
Exactly. And you will be called upon in the future, you may be called upon in such circumstances to do the same duty, isn't it? And you will do it happily.
Actually, you are quite wrong. Quite wrong.
Yes.
How will I be called upon to do the same thing if I'm a judicial officer? How will I be called upon to do it? It's not possible. But as a private sector lawyer, if I was a private sector lawyer, or if I, for any reason, reversed the clock and became a prosecutor and I had to prosecute a case, I'm not talking about these circumstances, I'm talking about any circumstances, I would undertake my professional responsibilities. Commissioner, the luxury of seeing things from the defense side is always one I find very strange.
So let me just finalize this because my time is up. So we went through experiences, and I'm saying this because I wasn't there, but these issues have been documented. We went through as a country from 1982, 1990, 1991. We went through all these experiences. And for you, when you look back, you're happy to say, I did my duty as a lawyer, and I'm happy with what I did. Is that what I'm saying? And if the same issue arose again, and I was called to prosecute or to do all those things, I would happily do it, isn't it?
If I was interviewing for a prosecutor's job, that would be a relevant question. I am prosecuting for a judge's job. No. So it is far-fetched, and what I'm trying to say, what is the right way? It's a misplaced question.
Okay.
Ask it another way, maybe.
I will not ask it another way. All I'll say is this: a man is his history, and we will judge you accordingly. Thank you very much.
Thank you. May I, Madam Chair,
Yes,
respond. In my years of prosecuting, in my years of defending, I have prosecuted, I have defended across the board. I've even defended the late Wangari Maathai in a case where she was charged against the government, just to show you that mine is the calling of an advocate. I don't judge those who do the case on their side, and those who attempt to judge people should always know that others judge them. So it should be more professional than that. Thank you.
And you are doing your job as a prosecutor that time?
I was certainly doing my job.
Okay, so I think no
one who has not been a prosecutor will understand it.
So I would suggest...
Sorry?
Okay, I'm suggesting commissioners and senior counsel that we take a very short break, maybe 10 minutes. We come back at 11:30, and then we continue with the interview. Thank you.
Thank you.